All right, everyone. Hello. Last class. I can see you're all enthused. Well, we've made it. We are at the road. I have a special treat for you. Usually, when you finish right around Hanukkah time, I have a tradition bringing gelt, these little chocolate coins, which is a tradition on Hanukkah, which we're nowhere near it, so I bring it for you anyway. Calvin, I think those are just for him. But as much as I love you, it's for everyone. So you can take whatever's left over. How about that? They're good. They're really good. So take as many as you want. The entire can is for you. Hope everyone has a good Hanukkah, a good Christmas. I won't see you then. You'll be angry at me by the time Christmas comes. I do try to grade quickly, though. I'm usually pretty good about this. Usually I have the grades in within about 2 weeks. So you should get them fairly soon. Although it's funny, some professors say don't be the first to grade, because when students get the first grade, they get agitated. But the second, they're kind of mellowed out. So some people actually withhold the grades deliberately so they're not first. But I try to get them early enough because I'll go on to other more important things. Okay, so yes, in our last class, it's hard to believe we are in class 24. We've covered a lot of material in a lot of different contexts, and it's been a good class. So everyone knows the deal for Wednesday is we're having a review session. Yeah, Wednesday, right? Yeah. So come here, 10:40, same deal as always. I'll proctor the exam for the first 90 minutes, and then we'll move to another class. I think it's 3:16. I'll tell you again on Thursday. I'm sorry, Wednesday, and then I'll go over the A+ example from last year. If you want, all the exams are online. You can do them before. I don't really care. But we should have a very good review. Come prepared with any questions you may have, or even if there are things that aren't on the exam that you're not sure about. I'll stay. If you have any more questions, I can answer whatever you need to know. My goal is to make the exam as painless as possible for those who prepare. For those who don't prepare, you are on your own. But if you do take the time to actually think about these things in advance, I will try to help as much as I can. Yes?
Open book, right?
Yeah, completely open book. As long as it's printed, whatever you want. No electronic notes, no tablets, nothing, just paper. You can bring whatever you want. Books, I really don't care. It won't help you. None of it will help you. It really, I mean that. It really won't help you. What are the questions? What else on your minds? Okay. All right, let's get started then. Oh, by the way, I have these evaluations for today. Can anyone volunteer to bring these upstairs? Thank you, ma'am. All right, I'll pass it out. I'll pass it a little bit later. Wait, don't forget. No class after this, so I have to do them today. Okay, so our goal for today in our final topic is to wrap up landlord-tenant law and focusing on something called the implied warranty of habitability. And in past classes, we discussed situations where, you know, the landlord defaults, the tenant doesn't pay rent. And usually, courts are likely to enforce leases. If the landlord does something wrong, the lease is breached. If the tenant does something wrong, the lease is breached. Today, we're doing a topic where it's not clear that something wrong has been done, but much later, the tenant comes and says that the circumstances were such that I couldn't pay rent. This is not the usual case. Usually what happens is when things get really bad in an apartment, the tenant leaves, vacates, stop paying rent. And we discussed in the last class how that works. But today, we're going to do a case that's actually pretty sad if you actually look at the facts in some detail, where this person continued living in this deplorable unit. And in this, yeah, I'll have a picture of it. They continue living in this really bad home, notwithstanding some very squalid conditions. And only then was there an effort to try to claim that something was wrong after the fact. Okay, so let's do the facts. The facts here are not pretty. It's tough to get through this and actually read this straightforward. Where did I finish last time? I remember. Let's walk through the facts, please. What happened in Hilder, please?
She paid the first month's rent and the damage deposit.
Good.
She was supposed to have the apartment cleaned, but they said that they could put the damage deposit.
By the way, I'll stop for 1 second. By the way, what was the rent, the monthly rent they agreed upon? Okay, good. So I did the math on this, right? So with inflation, $140 a month from 1974 is about $675 a month today. And I checked the real estate prices in this area of Vermont. There was absolutely nothing even remotely close. I checked Craigslist. I'm not checking anything expensive, right? There's nothing even in the ballpark. The cheapest comparable size place I found in this region was over $1,200 a month. So basically, even back then, if I can extrapolate, which is very poor, this place was roughly half as much money as any comparable place nearby. So I want you to keep that in the back of your minds when we discuss forward. All right, please go on.
In the apartment, she never got the deposit back because the apartment owner said he might get it from her in the first place.
Okay, good. And then the problems start after the garbage. So run through some of the problems that happened in this apartment.
Okay. There was a broken window.
Yeah, her poor kid was going to get cut with the window. So what did she do with the window?
After a week, she repaired the window at her own expense.
Okay, good. So we have a situation where there's a broken window, which is a serious hazard. She had a young child in the apartment. She told the landlord about it. Landlord didn't do anything, and then she, out of her own pocket, fixed the window. Okay, keep going.
She didn't have a key.
Yeah.
So someone always had to be home.
Yeah, everyone get that, right? She had to lock the apartment from the inside, right? So there has to be always someone in the apartment to lock from the inside because there was no key for the door. All right, keep going.
She purchased and installed padlock at her own expense.
Yeah.
The bathroom toilet was clogged and would only flush by dumping pails of water into it.
Yeah, so I mean, if you know how a toilet works, I've never actually thought about it. When you push the little button, the little thing, all water comes flushing in and basically puts the waste out. She had to literally dump buckets of water in there to make it work. All right, keep going.
There was no light or electricity operable in the bathroom.
Yeah, so she had to run an extension cord from another room, which is really dangerous, in order to get power so it can have any lights.
There's water leaking from the upstairs apartment down the ceilings and walls above her kitchen and back bedroom.
Uh-huh.
A large section of plastic fell from the ceiling onto the bed in her grandson's fridge.
Yeah, this is really bad. So basically, if I had to guess, probably lead paint based on the time period, is falling off of the ceiling, right? Because it's leaking water into this baby's crib, okay? It just finished up. We're almost at the end of the parade of horribles.
So she couldn't use the bedroom anymore. They had to move into the living room.
Good.
There was an odor of sewage during summer.
Yeah, right?
She couldn't have anyone in her apartment.
Right.
They found a broken sewage pipe in the
Yeah.
basement.
Yeah. I think that's it, but I think that's about it. Right, so this is a really, really bad apartment, okay? The situations are very bad. I'll repeat the thing I said before. It was also really cheap. Yeah, I mean, I ran the numbers on this. I mean, if you convert this to present-day dollars, I could not find anything on Craigslist, even this ballpark. So this is what the majority of people call a slumlord or something thereabouts, right? They're appealing to some sort of very low-income buyer who can't afford others. So, Ashley, when you first read this opinion, right, what went through your mind with respect to the mother living here? Like, what was your first thought reading this? Why didn't you stay there? Right? There's no lock on the door, right? Her kid has lead plaster falling into the crib. There's sewage permeating. And she was there for how long? Was it like almost 2 years or something? I mean, yeah, I mean, it was a 2-year lease. Actually, why did this woman not move out? Okay, that's the right. I think that's the right answer, right? Unlike the other case we did last week, where the police department can move out, or the prosecutor's office, right? I don't think she had anywhere else to go. It was her. Was it her nephew, her son, right? And some other members of 3 children, right? They had nowhere else to go. They couldn't afford anything else. The most that they could afford in this place in Vermont was this slum, which was $140 a month, which was probably all she could afford. And I suppose there are 2 ways of looking at this, right? I guess there's the Judge Posner way of looking at it, which you will do in a few minutes as well. If this is the best she could afford, this is what she deserves, right? If this is all she can afford, that's what the market provides. Another way of looking at it is perhaps, well, maybe the city needs to take more steps to provide low-income housing. That, you know, maybe the city needs to step in and either impose certain minimum, you know, housing standards for apartments, build some low-income housing itself, right? But both of these solutions come back to the same point. She stayed there because it was all she could afford. The question is, what happens next, right? Is it up to the legislature of the county or the city, whatever it is, to say, wow, we have this problem, people living in these really poor conditions. We need to maybe build some low-income housing ourselves. We need to create housing codes saying that if you're selling in this area, right, they need to meet certain minimum conditions. But neither of those things happened, right? The city, obviously, in Vermont, made no effort to build sufficient low-income housing for these kinds of income people. They didn't pass any kind of housing code. So as is often the case, the issue is then kicked to the courts. Judges who are then asked to make some sort of housing policy. And we'll discuss in the second case, with the Judge Posner opinion, what it means when you institute these housing policies, right? But the judges here said, listen, they brought an action before us, right? We have this case before us, and we can make some law. We can do something about it. All right, so before I get too far into the implied warranty of habitability, let's try and see if we can connect our last class. So what do you think? Based on our last class, right? Was there any doctrine we discussed that may have availed the mother in this case? Was there anything we discussed in the last class? Yeah. Yeah, what do you mean by that? Okay, very good. So we did constructive eviction last week, right? Where the conditions are so bad, even though you're not physically evicted, the conditions are such that, you know. So with constructive eviction, you have to leave. Yes. So the deal is that with constructive eviction, you have to actually leave. Remember we said we were taking a gamble, right? You're taking a risk. Because by leaving, you're hoping a court may agree with you that you're constructively evicted, and therefore rent is not due. So she could not avail herself of constructive eviction because, again, she didn't leave, right? Meredith, what else? What's one other thing that happened in this case based on the facts that perhaps the mother could have brought? I keep calling mother, grandmother, whatever, that she could have brought under property law based on what we did last week. What do you think? Before we get to the implied warranty. What was that covenant of quiet enjoyment? Well, okay, so anyone know what the covenant of quiet enjoyment is? Yeah. Yes, exactly. So the covenant of quiet enjoyment refers to someone asserting a claim, a legal claim to your property, right? Someone saying, "Oh no, I own that apartment," or "I have a lease to that apartment." That didn't happen here, right? There was no one else who wanted to live there, right? No one was claiming a competing claim. What about Adriana? What about the fact that she couldn't use the bedroom because of falling plaster into the baby's crib? What about that? What could she have done with that part of the claim? What could she have asserted? Well, was she evicted from the entire apartment? But could she use that room? What do we call that? Not actual eviction. What do you think? Remember? Partial. Bingo. Partial. Do you remember we discussed this last week? Remember with the basement evidence unit, and one of the rooms was kept getting flooded. Said, "Oh yeah, you can use everything else. Just move your evidence somewhere else, right?" And this may be a case for partial eviction. Look, she couldn't use the bedroom because the plaster was falling, right? I mean, I could actually make the argument, which is not crazy, because there was no damn lock on the door. The entire thing was basically unusable, right? There was raw sewage seeping in to the bathroom, whatever. I think that's unusable, right? If a toilet is so clogged that you can't even flush the thing, I think you can make a not terrible case for a partial eviction, right? I think you could, but they didn't raise either of those claims. All right. So what's interesting, Samantha, let's go back to you. So in this case, how did this case get to court? What was the nature of this cause of action? Right. It was a case where the plaintiff stopped paying rent. Exactly. And this is what's so strange about this case. You would think, and this goes back to the question I posed to Ashley, right? You would think that this one would stop paying rent, saying, hey, listen, I'm not going to give you another $1 unless you fix these things, right? But she kept paying her rent on the month, one after another, which is another astonishing thing about this case. So what was the nature of this lawsuit then, Samantha? Why, after paying this rent, what did the grandmother try to accomplish in court? No, what was her lawsuit? What was she seeking in her lawsuit? Be more specific. Yes. She was seeking to get back the money she paid in rent, right? Plus, she wanted compensatory damages, and she wanted punitives. We'll come back to punitives in a minute. Yeah.
You have to assume, I guess you could imply at least that she had no idea that she could have a cause of action. So someone must have said something to it.
Well, that's an interesting point, right? So we'll get there in a few minutes, but in this case, the Vermont Supreme Court changed the law, right? Right? They basically implied this warranty. When she brought this suit, did that cause of action even exist? No. Right? So here's an interesting thing. I think Andrew raises a fair point, right? While she's living here month to month, could she have brought under prevailing Vermont law this lawsuit? The answer is not really, right? This cause of action didn't exist. And it was only by bringing this suit, which I think was a test case, if I had to guess, right? By bringing this suit, she was hoping the highest court in the state could recognize this cause of action. So basically, this was a complaint filed based on something that didn't exist in the state of Vermont, and they were hoping, right? So in other words, she brought this suit seeking, roughly $5,000, which is all the rent paid for 14 months. She sought compensatory damages, and she sought punitive damages. Okay, and the trial court basically gave her almost all the, all the rent that was owed. He added on $1,500 compensatory damages. It's not clear how he came up with that number. It didn't really specify. And he denied punitive damages. Okay. So a couple of things you have to remember of this. One, she never abandoned, right? She never left. Two, she continued paying the rent. And under the common law, it's presumed that if you stay there and keep paying the rent, it's not that bad. Right? As horrible as these circumstances are, under the common law, if it's so bad, you would have left. If it's that terrible, you would have withheld paying rent. She did neither. So under the common law, her case does not look very good. She has a fairly weak case under the common law. But of course, we are on property, and the common law is not long for this world. So Jacqueline, how did the court address this common law rule of caveat lessee? How did they address that rule?
Well, they talk about they talk about the common law, and that basically under the doctrine of caveat lessee, she should have left the premises. She can't recover, but they say that the law has kind of evolved, and so they essentially overrule that doctrine, and they go into implied warranty. Very
good. Very good. Okay, so we have this doctrine. You've heard of caveat emptor, right? Buyer beware. This is caveat lessee, that the person taking a lease has to be why. And this doctrine is based on the idea that when someone signs a lease to a piece of property, they're not leasing the house on top of it, they're leasing the soil. This goes back to feudal times, right? When you buy a piece of land, you're not buying whatever's on top of it. You're buying the land itself, the earth, right? With size, and you take a clump of the earth and you twiggle, right? Remember? That's what you're getting. So it really wouldn't make much sense if that was your sense of property to require houses to be in a certain situation because you're not actually buying the house. In a similar vein, people who were buying land back in medieval times were a lot more handy than they were today. I am not handy. I don't know if any of you are. I can't fix anything myself. When something goes wrong, I send an email to the rental office and they come fix it, right? That's how today. So this notion that people are handy, can fix their own problems, doesn't necessarily carry as much weight today. Today, you have a lot of urban dwellers who live in cities, like myself, who are not able to fix their own premise. So it doesn't make quite as much sense to require them to be able to fix these things. Okay? So I think we all agree that far, right? That this notion that the conditions on the land matter. But where the court goes beyond the common law to say constructive eviction is not enough. Why? Constructive eviction historically was the remedy here, right? If the conditions were so bad, you move out. Right? If the conditions are so bad, you stop paying rent. What makes this case more difficult is a person remained in the unit. And this may be due, like Ashley said a few minutes ago, she could not have afforded to live elsewhere. That might be the case. So then the court starts walking us through modern landlord-tenant law beginning in the 1960s. So a lot of cities began imposing requirements saying any apartment in this area must meet certain conditions. And there's really nothing wrong with the city or county, whatever, imposing those codes. Cities did not impose those types of codes, right? So Ashley, let me ask this question. Say you're in a city that didn't impose any kind of housing codes on apartments, and you're a tenant. Could you demand any protections from the landlord in a certain way? Well, put aside realistically, theoretically speaking, could you?
If they weren't required by the city or state to do anything.
But
I'm sorry.
in theory, could you ask a?
Yeah, you could ask.
Okay, so you're right.
Sorry.
You're right. I mean, you already jumped to the next question, right? So in theory, right, the landlord and tenant can agree, saying, okay, I will maintain a certain level of quality of the heat, of the sewage, you know, of the electricity, whatever, right? But to answer my next question, as a practical matter, landlords usually don't have incentives to do that. Why? Because landlords' incentive is to make things as cheap as possible for them while extracting the most money possible. That's the nature of the game. And by the same token, tenants want as much as possible for little rent as possible. So there's this inherent tension, right? So one way to overcome this problem is from a city to impose some sort of a minimum housing standards or housing code or whatever, right? Allison, why do you think cities didn't impose these kinds of requirements? Why don't you think every single city in Vermont imposed a housing code to protect these, these slums?
I guess they really just didn't want to be in like somebody's like private business.
That's a good. It's a very libertarian answer. I like that one. But another is, why do you think that the cities didn't enact these rules?
I guess maybe like the negative consequences that would have come from it. Like
Elaborate. Yeah. Say more.
I remember reading through cases. Reading through this case, they said that there were some problems with like when you would have rent-controlled apartments. I believe maybe.
What are some of those problems?
Let's see. I can't find it. I don't remember reading those.
Derek?
Would be the cost of living would go up, because then you have landlords that are selectively, going through the pool of tenants to see who is, I guess, who can pay an elevated rent, because the landlords would shift the cost over for repairs and the rent.
Okay, good. Christian, finish it up.
Not only that, they would be more selective with who they pick. So It'll be less.
Wow, you are such good students of mine. Yes, you've all given very good law and economics answers about why they didn't do this, right? The sad fact is, when you make housing conditions better without putting a ceiling on rent, you increase the rent. That is an indisputable fact, right? When you do not put a ceiling on rent and you require things to be nicer, you make the rent more expensive. So say the rent here was $140 a month, and maybe she could only afford $140 a month. If you require the sewage to be fixed, and you require the window to not be shattered, and you require the electricity to work, and you require putting a lock, right? Say their rent went up to $200 a month, right? She can't live there anymore. She can't afford to live with her wife, with her kids and grandkids, whatever, right? What happens then? Well, we can talk about what happens then in a minute. But the libertarian economic analysis says, well, the members of the city council were very sympathetic to the plight of the poor, and they kept the housing conditions poor so they could afford things. So what's the cynical answer to that? What's the cynical answer about why cities did not institute these kinds of rules? Who do they care about? Who's more likely to lobby for landlord changes, the poor people in the town or the landlords? There you go. So if you want to talk about footnote 4 of Caroline Products or any other context, right? The people with the outsized lobbying influence here are the landlords. If you're on the city council, and politicians are, right? You ensure that the landlords are happy. And the way to keep the landlords happy is by not imposing housing codes. The flip side is when you have an oversized tenant population like we saw in Chicago, they can actually pass laws that purport to benefit the tenants. Although, as I think Posner illustrates correctly, this is not actually benefiting tenants in any meaningful way. But we'll get back to that in a second. But at a minimum, and avoiding typhoid, right? At a minimum, city councils will be loath to institute codes that make housing more expensive. I think all of your reasons are good, but the latter one's probably more cynically realistic. So in the absence then of any legislative solution, it falls, as is the case here, to the courts. So Jason, how did the courts handle the situation where the legislature didn't really impose a housing code and there are these conditions very bad? What did the courts do in this case? Do you have it?
Yeah.
Okay. What did they do? What did the court do in the absence of any legislative imposed housing code? How did they rule in favor of the grandmother here?
They said she could withhold future rent payments until the problems are resolved.
What legal doctrine do they base this on?
What's
the name of this legal doctrine?
Warranty of habitability.
The full name. You're missing the word at the beginning.
Breach of warranty of habitability.
You're missing one word. Implied. Good. You're 2/3 of the way there.
Breach of warranty of habitability.
Thank you. You never spelled this word right. Habitability. Right?
Sorry, my notes are just a little.
That's okay. You talked yourself into it. Okay. The implied warranty of habitability. This is a doctrine that courts have recognized. Okay, so you might remember in contracts you had the implied warranty of merchantability. That sounds familiar. Goods sold in a certain manner have to reach a minimum level of, quality, however it's defined by commercial standards, right? The implied warranty of habitability operates in much the same way, right? So let's just break it down one word at a time. Elizabeth, what does this mean for something to be implied? What does that mean? I can't hear. A little bit louder. Louder. I couldn't hear.
Is it inherent?
What does that mean, inherent?
It's just no.
So did this doctrine materialize out of thin air, it just came out of the ether? Did it one day just appear in the law books? Where did it come from? And the question you always have to ask is, who implied it? Who did the implication? Courts. Courts. This word implied is a beautiful word because it hides the ball, right? If they called this the court-imposed doctrine of warranty of habitability, it would not be very popular. But make no mistakes, my friends, right? Make no mistakes. When someone says you have an implied doctrine, that means the courts read it into the law, right? This isn't a code by the city council or the legislature, right? This is a code imposed by the courts. And the courts say, you know what? This doctrine is so important, we're going to pretend every single lease answer, could the parties have agreed to a warranty of habitability? Could they've actually added that warranty to their lease? Of course they could have. As a practical matter, will they do it? Of course not, right? So the court said, you know what, you slumlords, if you're not going to do this, we're going to do it for you, right? If you're not going to take the responsibility to make sure that the apartments you're renting have certain levels of quality, we're going to do it for you. And they insert this implied warranty of habitability to every single lease. And Ava, can the parties waive this implied warranty? No, they can't. You cannot get rid of it, right? Say we have the same situation where this grandmother was faced with the choice. Said, all right, listen, I have one apartment that's in really crappy condition and the rent's $140 a month. And I have this other apartment that's in not good condition, but habitable conditions. That's $200 a month. But you have to waive your warranty. Which one do you choose? There's no choice there. You cannot rent an apartment that contravenes this implied warranty of habitability.
How about with further consideration, like if you fix it up, I'll give it to you for this price. So a person who's living there and serving as a maintenance person.
So let me ask you this question, Calvin. What happens if the tenant then brings a suit against you for violation of implied warranty? Will that promise get you anywhere?
It should, according to what we just read.
It won't. So that's the deal. If you're a landlord and you know that if you rent an apartment to someone that violates this warranty, you're subject to a lawsuit. And whatever rent you get paid, you have to get back, plus damages. So this basically tells landlords, okay, I'm not doing anything that doesn't meet this minimum level of quality, but I'm going to jack up the rents to make sure that I'm compensated for this, right? This is the lesson the Posner case teaches. Nothing is free. Everything has a cost. Everything in life has a cost. When you make something better for someone else, it makes it more expensive for someone else. There's no way around it. It's like the fourth law of physics. You cannot avoid cost, okay? So what is then this implied warranty of habitability, Juan? What does it include? I mean, how does the court define what minimum standards of habitability an apartment must have?
Basically, the tenant must, the condition of the premises must be in good repair, must be habitable. I mean,
Yeah, be a little more specific. What are some things that have to be? James, you know some of the specifics?
Let's talk about the low-known package of goods and services.
Good, yeah. So flesh that out.
So adequate heat, light, ventilation.
Good.
Plumbing facilities, windows, doors.
Good. Yeah. So heat, light, water, sewage, doors, safety, right? Basically, all the things that were horribly wrong with this poor grandmother's apartment have to be fixed. All right. This isn't to say that you need to have. This is a pretty minimal standard, right? It basically means like the light has to turn on, the toilet has to flush, the door has to lock, right? We're not talking about, having a good air conditioning unit that keeps you cool all year round, right? You need to have some minimum levels of standards. Was that?
No hanging hot electrical wires.
Yeah. Like the outlets have to actually have power, right? Like really minimum stuff that has to happen. Andrew, how is a court supposed to decide whether something should include this implied warranty of habitability? What sources are they supposed to look at? Where are they supposed to base their judgment on? You got it?
Minimum housing code?
Good. Well, one thing they can look at are various housing codes, right? What happens if a city doesn't have a housing code? Which is often the case back in the 70s. In this case, Rose. What do you think, Phil?
They look at essential facilities that are vital to
Yes.
residential living.
So at this point, the court's looking to their own sense, right, of what's necessary to have a safe apartment. Right? They're looking at what we think is vital and essential. So effectively, the courts can write housing codes, which is effectively what happens here. One thing, though, that's important, though, is that the tenant must notify the landlord that something's wrong. The reason why this is important is that it gives the landlord a chance to fix things, right? Because you can imagine a problem where tenant's living in this bad apartment, never says a word, and then all of a sudden he sues for back rent, right? So you have to at least notify them. All right, so let's talk about damages now. So Sonia, what is the what is the measure of damages, right? How do you go about figuring out how much of the rent can be retrieved? Okay, so tell me one. No, I'm talking about the damages for the rent. Basically, so the nature of the suit was saying, listen, I paid yours, I want the rent back. So, but what's the formula a judge needs to know to calculate the correct amount of rent to the tenant gets back?
I guess they're just looking to see, I guess he has the right to make it to use rent.
Well, here's the thing, right? Let's just make it easy. Let's say they paid $100 a month in rent, right? Do they get back to the full $100?
Yeah.
Do they get any value for living in the apartment that year?
They did, but then it set up a.
Okay, so it's interesting. It's interesting, right? The general formula, and this is probably very similar to what you've seen in contracts, right? About calculating damages, right? So you take the difference between the value as warranted minus the value with the defects, right? So say that the warranted value was $100 a month, right? Let's make it easy. Okay, and we know that she got back $100 a month. If that was the case, right? What was Stephen? What was the actual value of the unit then? If she got back a full 100? No. 100 minus what equals 100? Zero. Yes. You take the value as warranted, which is effectively the rent price, minus the value of the defects, right? What's the value of this land with the defective conditions, right? Basically, what the court held is that even though she's paying $100 a month, the value of the apartment was zero, and she's entitled to the entirety of the rent back, every penny. Everyone see that?
Often does that happen?
Well, what do you think?
Probably not very often.
Why do you think not very often?
Because there are people arguing that even if it's a crappy place to live, it's still a place.
It's still a shelter, right? It's still a roof over your head. So I think this has to be wrong. You don't need to take my opinion for it, right? I'm with you. This apartment was not worth a lot. Give her $1, right? Say that there was some value. It was a roof over her head. It was a door that eventually locked. It was a toilet that kind of flushed, right? So make it $1, right? But in fact, what the court's saying here is the value of the apartment with all those defects was nothing, zero, zilch, not a squat, but bupkis, right? I don't think that's right. And I think even in the court's opinion, they suggest that this won't always be the case. But what they're trying to show is that when something is in such terrible conditions, that it's not worth a penny. Questions on this one?
think they sent him a message too. They call him a slum.
Yeah, exactly. Right. I think they call the tenant, I'm sorry, the landlord a slumlord, and they're trying to send a message saying, listen, if you want to do this, be prepared to have to pay back every penny of rent you got.
Didn't they take into consideration that she fixed the things and spent her own money on fixing the things as well? So did they add that into there?
I mean, yeah, so that would discount some of the rent, but that wouldn't get you back to all of it. Right? Whatever the value of the fixing the window was and cleaning out the garbage, I mean, that's maybe a couple hundred. But they still awarded the full value of the rent. Okay? So beyond, though, actually the damages, right, of the rent, what other damages were there, Samantha?
The punitive damages?
No, let's not get the punitives yet. What other compensatory damages were there?
What other one, I'm sorry?
Oh, by the way, everyone know the word compensatory versus punitive. You may have seen this. So generally there are two kinds of damages, right? Compensatory and punitive. Compensatory damages compensate you, right? Pay you back for your losses. So that would include, you know, the back rent and in this case, discomfort and annoyance. Discomfort and annoyance. That's often called pain and suffering. Has anyone ever heard that expression? Yeah. It's usually called pain and suffering. I don't know what they call it. It's basically the same thing, right? In any kind of tort, right? Say you get into a car accident. When you're seeking compensatory damages, like your medical bills, right? That's a very specific amount. You can say, look, here's my bill from the hospital. Here's how much the ambulance costs, right? You can show that. But beyond compensatory damages, you also have things like pain and suffering. So you might have said, you know, I had to, you know, go to rehab for 6 months. And, you know, my favorite, the loss of consortium. Ever remember that one? The loss of consortium. I couldn't consort with my lover, right? Whatever you couldn't do, right? So there's always pain and suffering beyond the enumerated, you know, medical bills or rent in this case, right? So Shelley, in this case, what were the discomfort and annoyance or the pain and suffering that the court seized on when discussing the compensatory damages?
I think, 1,500?
No, not the amount, but what made it up? Like, what were the things that made this so much pain and suffering?
The failure to make the repairs.
What was so bad in this apartment that would cause her to have suffering? Just if you don't know, you can. It was unsafe. Yeah, it was unsafe. Look, there was no hot water. They couldn't take a bath. There were rodents running around where there were children. Right. They had to avoid rooms when it was too cold. Right. They couldn't bring company over because of the sewage. Right. So there were serious aspects of pain and suffering. By the way, yeah, no, that is a minus sign. 100 minus 0 equals 100.
I mean, like that one.
Oh, that's a dash. Okay, it's a dash. Okay. But the problem was calculating pain and suffering is one of the hardest things for a court to do, right? How do you put a price tag on how these children have to run around with like rats, right? How do you put a price tag on, you know, no hot water for taking baths? So Amanda, what does the court do to this report award of $1,500? Do they accept it?
Well, they said that it was, they didn't understand how the court reached that amount.
Exactly. So the Court of Appeals rejects this $1,500 award, right? Why? Because there's no indication of how they come up with that number. So the deal with pain and suffering is that unless you're a jury can just say whatever number they want, right? But if you're a judge, you need to provide some metric of how much this hurt you. That's a very hard thing to do. How do you put a price tag on having your children not have a hot bath, right? Or that your grandkid has to run around with, you know, plaster falling into their crib, right? How do you put a price tag on that? I don't know if you can. In fact, I once had a bench trial while I was clerking. And this is a really messed up case where a little complicated. So this guy, his son shot himself, committed suicide in a very tragic manner. So he was in Georgia. They went to Pennsylvania and they bought a casket. And they thought they were buying this expensive bronze casket, but it was basically a knockoff. It was made out of steel. And they basically kept the body in there for some period of time. And they embalmed it. And they were building, like, you know, a mausoleum above ground, this huge stone mausoleum. So as they were building it, the casket started leaking. Oh, it was really bad. So basically all the fluids came out. I mean, it was a mess. So they had to transfer it to another casket on very short notice. And this was, I mean, this guy had lost a son. It was a really bad situation. So they transferred to another casket on short notice. The problem was this new casket was 6 inches wider than the other one, and it wouldn't fit into the mausoleum. So the genius building the mausoleum said, I have an idea. Let's shave 6 inches off the stone walls on the side. So they put the casket into this new mausoleum with the thin walls. And as you may imagine, it started to crumble and crack. So the entire mausoleum started to crack and crumble. So this poor father, they didn't want to move the body again to a third casket because they left it there. They sued the funeral home for selling them a bad casket. That by selling them the steel casket, they would have to pay damages for the mausoleum. And the court held absolutely not. It's not foreseeable. But calculating damages on that, can you imagine for a father trying to figure out, have to take his son's corpse out of this decaying box and then transfer it, having the thing crumble? I mean, that was my only experience, but I was trying to come up with a number for them. Like, how the hell do you come up with that? I don't know. But you need to do something. You need to say something to give a number for it. All right? So we have the back rent. We have the pain and suffering. So those are compensatories. Now we go to the punitives, which are called punies, if you want to be cool. They're called punies. So Carrie, do you remember from your other classes where punitive damages are usually allowed and where they're not allowed?
Usually they're allowed when it's trying to deter certain conduct.
Which class mentioned punitive damages? Torts, right? Do you remember the word punitive ever being mentioned in contracts? Do you remember the word punitive ever being mentioned in this class? Okay, that's right. Generally speaking, torts, usually intentional torts where there's serious egregious conduct, right? That is where you can have punitive damages. And as Carrie said correctly, punitives are meant to send a signal. They're meant to punish people, puny, punish, right? And say, don't do this conduct again. We're going to try and deter this conduct going forward. But generally in contracts, the measure of damage is compensatory. There was a contract, you breached it, so let me pay you back whatever it cost because of the breach, right? But here they find that punitives are okay, right? Why are, Emily, why are punitive damages permissible?
Because it was an intentional conduct. Well, the pattern of intentional conduct.
And not just was intentional, what made it subject to, rise to the level of punitive damages? I'm sorry, I think you said, what did you say?
It was so terrible.
Yes, yeah, I thought I heard that. It was so terrible. Basically, yes. This is such an egregious, horrible conduct that basically ruined this woman's life, right? That they need to have punitive damages, right? And again, they're trying to send a signal to others, don't be a slumlord, don't do this. But although in this case, it seems a punitive issue is waived, so they don't have to award them here. That's how the court gets around forcing them to pay punitives when that wasn't the law beforehand, right? They just made up this new rule, and they found a way not to enforce it against the old parties.
Now, but like
Going forward, yes. Going forward, punies are in the ballpark, right? You can get punies. Judges don't like wearing punitive damages. They don't like doing it because they can get reversed very easily. All right, so we now have this implied warranty of habitability, right? And this changes the ballgame. Before, when you had this doctrine of constructive eviction, if the conditions were so bad, the tenant needed to move out and stop paying rent, right? And once a tenant moves out and stops paying rent, Arib, what happens usually then? What's the first thing the landlord does when the tenant moves out and stops paying rent?
Well, he wants them back rent.
And what will he do? Sue, right. So here's what happens, and this actually makes sense, right? Conditions are bad, the tenant moves out and stops paying rent. You go to court immediately and work this out, right? But what happens here, Dylan, in contrast? They continue paying rent, right? So what can end up happening is the conditions are bad and the person continues paying rent. So the suit can actually arise in a slightly different situation, right? Say the lease is over, and after the lease is over, the tenant brings a lawsuit for back rent saying, hey, these conditions are so terrible. Okay, so that's possible. But more likely what happens is the tenant stops paying rent and he stays. The most likely application of this doctrine is the tenant stops paying rent but he stays. So Jonathan, I'm sorry?
Actually stay.
He stays, yes. So Jonathan, what usually happens when a tenant stops paying rent? He sticks around the apartment. What usually happens then? Yeah, exactly right. So the way this usually comes up is that the landlord will move for an eviction, right? He'll say, listen, my tenant's not paying his rent. And you'll try and do, remember that summary eviction process we discussed last week? Like in Texas, it takes roughly a month to evict someone. But here's a different deal, right? Usually with summary eviction, the only issue is, was the rent paid or not? And if the judge says there's no rent paid, they issue an eviction order. But Calvin, what happens differently here?
This tenant stayed and they pay rent.
No, assuming he stopped paying rent, and in the situation I just mentioned, right? The tenant stops paying rent, and then the landlord tries to evict him. What does the tenant say in court?
But they breached the warranty of
Exactly.
implied warranty.
Exactly right. The tenant says, you have breached the implied warranty of habitability, therefore the lease is null and void. I don't owe you any rent. Not only that, you owe me back rent for the months where the conditions were bad. So this gives a very strong, what's called an affirmative defense, right? You've probably seen this phrase elsewhere. Affirmative defense, which basically means, yeah, basically, yeah, I didn't pay you rent. And do you want to know why? Because when you breach this implied warranty, you breach the lease. Because the lease is no longer in effect, I have no obligation to pay your rent. So this will often be a way, I don't use this in a pejorative phrase, but to drag on eviction proceedings. Now, there may be a valid claim, or there may be a not valid claim. But in any event, once someone raises implied warranty, that involves fact-finding, that involves some litigation, and that stretches out the process to evict someone. Okay? So the implied warranty of habitability gives another defense for someone getting evicted. And I don't mean this, again, to be cynical, but very often people will assert this for no other reason than to drag out the eviction process, right? Finding a violation of the implied warranty of habitability is not easy. I think was selected for your book because it was such an easy case. Like, you had 15 things that were really bad. Like, most of the time, if you have, you know, a broken window, right, or the heat's not working, if you have one or two things, that's not going to cut it. What made this case so unique is they had like everything one after another. So it's going to be the case more often than not that you do not find an implied warranty of habitability breach. In fact, most cities have housing codes that solve this problem. Okay? All right, so questions on this? Oh, yes, please.
The implied warranty of habitability is only applicable to your residential tenants, your end users that are living there.
Yep.
Whereas your leaseholders, like the lawyers and stuff like that, theirs was
A commercial lease?
yeah. They have another. What was their defense that they used?
The constructive eviction, wasn't it? You're talking about the prosecutor case from Indianapolis?
Yeah, when they're
Yeah, I
down
think-
at the bottom of the building, but did they have a defense available to them due to?
Well, no,
flooding?
no. I don't think I don't know Indiana, but usually the implied warranty of habitability doesn't apply to commercial leases,
Okay.
right? This is residential.
I was just thinking whether they had the option. to
Yeah,
say
I mean
it's
that
not
was a
paid.
commercial. I mean, the entire essence of habitability. Habit means living.
Right.
No one lived there.
That'd be for a certain time, or do you just have like, just, not necessarily the housing season in like June, or if it's just heating in Michigan, in December.
Right.
For 1 month, you not pay that 1 month and have that defense.
So generally speaking, that's right. You're only exempt from the rent until the condition's fixed, right? Once the condition's fixed, your duty to rent resumes. Although if your heating in Michigan dies for a month, you're probably in serious trouble. It's really cold up there. I mean, whatever you guys are chilling today, this is a balmy, it's a warm day for Michigan. I've been there in the cold winter. It's not fun. So another hand somewhere. Yeah.
I was kind of wondering what kind of conditions have to meet this habitability. Can it be, for example, like an infestation with roaches, or?
So the court doesn't, and again, this is Vermont law, but the court doesn't spell out exactly how this works. Generally, as a housing code, which I'm sure Houston does, you look at what the Houston Housing Code says. I know the answer to that question. But more specifically, you usually need several things. One is not going to be enough. So if it's the roaches, you have roaches, no power, sewage, all these. The general gist is it's going to be very hard to establish a violation of this warranty. It's not going to be easy. And because it's not going to be easy, it doesn't get you very far, right? It also requires litigation. So think about this case, right? This woman paid almost $4,000 in rent over the course of, what, a year and a change, right? She didn't get her money back probably 4 years later. This is not a very practicable means for people to get their money refunded. So where it comes in is someone says, listen, I'm not paying my rent until you fix this. And that's usually enough of a threat to the landlord to fix the thing so they can actually get their money back. Other questions? Yes?
If there's a housing code in place, then assuming they'll probably be other ones.
Yes, exactly. So if there is a housing code in place, right, you basically bring a private cause of action under the housing code. You don't need to bring an action under this implied warranty. You say, listen, here's the housing code, right? It spells out you have this, this, and this. You don't do this. Court figure it out. But that gives a, when a legislature makes a standards, they can spell things out in very detail. When a court implies these warranties out of thin air, it has to be very vague by necessity. So there's serious housing code based on a what the city code designs. Other questions in this case? All right, so again, we see this move towards contract-based remedies. And with tort like that, no. So we see this move towards contract-based doctrine with tort remedies, where you can actually have, contractual law plus punitive damages. So judges, when left to their own devices in property law, have really run amok. Where they take a little bit here, a little bit there, and before you know it, there are too many cooks. And it's a serious problem. Okay. Virtually every state now has some form of the implied warranty of habitability. It's defined slightly different, but again, this is somewhat moot by the fact that if you have a housing code, it's not really necessary to go through these details.
At this point, how many states have housing codes?
I think all 50 have housing codes.
Okay.
But I mean, local cities may not have them, right? So housing codes are not usually statewide. They're usually countywide or citywide. So if you're in a small county in the middle of nowhere, they may not even need a housing code because there are no apartments, right? No, I mean, so I'm sure all 50 states have them in various cities and counties, but I'm sure there are a lot of counties that don't even have or need one. But I think the book said that only market habitability or something like that, but it's basically everywhere. Okay. All right, and the book has a couple interesting anecdotes about like Manhattan, right? Someone asked me about rats. So they have one case where in a high-rise in Manhattan, the staff goes on strike, and the garbage starts piling up on the sidewalk, and because the sanitation workers won't cross the picket line, it becomes a serious health hazard, and the building is condemned, right? Is that implied warranty of habitability? Yes. So basically, the landlord has to keep things in a certain habitability. This actually came up a couple years ago with Hurricane Sandy, where most of lower Manhattan, tropical storm Sandy, superstorm Sandy, where most of lower Manhattan was flooded. And because of that, you didn't have power in lower Manhattan. And if you don't know this, the way you get water up to the top floor is with pumps and electricity. So you had entire apartments, these these luxury buildings that had no water, and they were condemned because they weren't habitable. So you have these, these $6,000 a month one-bedroom apartments, in the financial district, which had no power, no water, were being condemned. And people couldn't even go to their own apartments. This came up quite a lot. All right.
So in those cases, breach of implied warranty?
Well, I mean, it's a violation of the city housing code because you need to have a minimum running water, and because the pumps weren't on to pump water up to the top floor, so there's no running water.
I mean, cumulative damages goes to intent, basically mental state, but this is pretty much, you don't care what's going on. No, breach of implied warranty.
Well, usually it's, you don't really care enough to provide habitable circumstances for someone, and you want to do it for as cheap as possible.
Yeah, but if he could if the landlord had no way of providing these things because the pumps wouldn't get the
Right. I mean, the hurricane situation, there would not even be close to a case of punitive damages because it was unavoidable. It's force majeure. Everyone know that word? It means act of God. You'll see this very often. Force majeure, which means basically act of God. I think I'm spelling the second word wrong, but that's close enough. It's French. It means act of God, where it's just circumstances beyond your control. So there's a hurricane very often. This happened a lot with Katrina, where basically the insurer said, whoa, act of God, can't help you. You're on your own. And this issue is hotly litigated. All right.
So there would be like somewhat of defense. They may not get punitives, but they probably get something. They may not have to pay the rent.
Something like that, right? When you're in circumstances beyond your control, where the city's not providing electricity and it becomes impossible to pump water, right? Right. That's flood damage, not hurricane damage. Yeah, basically, there's actually a big deal with Katrina. It's like whether the hurricane did it or whether subsequent flooding did it. This came up a lot. You can go take a class on tort law with Katrina. It's an interesting topic. All right, the book has a note on retaliatory eviction, right? And I'll just say a note on retaliation, generally speaking. Retaliation generally means when a person reports a problem, and as a result, the person who they reported to acts against them. So the classic example is an employment law, right? Employee says, hey, boss, I don't like that you're discriminating against me because of my disability. And then like a week later, the boss reassigns the person to a job that's lower paying. The presumption in such cases is that the reassignment was due to the complaint. So the same doctrine applies to housing. So say, the grandmother went to her landlord and said, hey, I don't like it that my sewage is leaking and the lights don't work. And then like a week or two later, he says, oh, guess what? I'm evicting you. Canceling your lease. Don't want you anymore.
Doesn't it say it's only within 90 to 120 years?
So the time on that varies. So usually within 3 to 4 months.
So it's all right if in like day after month 4 you just do it.
Well, Lou, right this way. Yeah. That's actually an interesting issue, right? So say you complain on January 1st and you're evicted 6 months later, right? For totally unrelated reasons. Under that standard of law, it's still presumed to be retaliatory. And there's actually a rebuttable presumption. In other words, the landlord say, oh, no, here's why I evicted the person, X, Y, Z. But the landlord has to come forward with reasons why. That seems to me a very long time period, but landlord-tenant law doesn't necessarily always make sense. In New Jersey, someone laugh. In New Jersey, of all places, you actually need, quote, good cause, right? Which basically means failure to pay rent. In most places, you can evict someone at the end of their lease because you don't like them. But in the Garden State, you actually need a good reason to evict them after the lease is over. Yeah, it's interesting. Don't worry about the tort liability stuff. It doesn't really matter too much. Okay. Let's go on to the last case, the Chicago Board of Realtors, the City of Chicago. So before I even go that far, I feel obligated to discuss my our dear friend Judge Richard Posner. So what's interesting about Judge Posner is that he can write faster than you can read, and I don't say that lightly. There's a joke among lawyers: don't get into a fight with someone who can write faster than you can read. He's probably one of the most cited judges of all time, and there's a note about that in your book. Prolific is that he writes at ridiculous paces. He puts out a book every year with being a full-time judge, and he writes op-eds and editorials on a monthly basis for various publications. I think, and I've gotten in trouble for this, I think most of his writings are inappropriate. If you were a judge, you should be being a judge, and you should not be weighing in on these other issues. Salient for you is that he's actually picked many fights with the Supreme Court, and he routinely criticizes Justice Scalia, and Justice Scalia once pulled rank and said, well, he's a circuit judge. I'm a Supreme Court justice. We don't listen to him, which I find very funny. So he's an interesting guy. But one thing that he's most noteworthy for is the so-called Chicago School of Economics. He was a law professor. And he brought to the forefront the idea of law and economics, that you can have legal principles based on economic efficiency. And his colleague on the Seventh Circuit is Judge Frank Easterbrook, who's also quite. The two of them have an IQ probably collectively higher than most courts of appeals. They are really smart people, and I don't say that lightly. So Posner and Easterbrook are probably 1 and 2 as most cited appellate judges are close to it. So this case presents an interesting issue, right? Where was I up to? Oh, yes. So Sonia, you have it? Yes. Okay. So Lou, what was the law passed by Illinois in this case? What did the law do?
In the case that we're.
Yeah, in the Chicago case.
That there is
The law, the law passed by Illinois in the Posner case.
Oh, in the
Yes.
I think. Okay.
Yeah, there were 2 cases today. The second one. What did this law require?
I mean, I can, if you give me a second.
I'll come back. Maria, what did the Chicago law do?
It requires landlords, like responsibilities and tenants more right.
I'm looking specifically what did it do?
So landlords now, like things like the deposit, they
Good.
had to hold it in Chicago. In the Illinois bank.
Very good.
They have to allow the tenant to withhold rent in a certain amount,
Good.
reflecting the cost of the lease.
Very good.
And then they could subtract the repairs from their own rent.
Very good. Very good.
Okay, they were forbidden the landlords to charge a tenant more than $10 a month for late payment.
Okay, good. Right. So Chicago, the windy city. I was there. Windy, very cold. The city of Chicago passed a law that was meant to protect tenants, or at least that's what they claimed it protected. And it did a number of things, right? It codified this implied warranty of habitability. It said that any security deposits have to be held in an Illinois bank. Tenants can now withhold various amounts of rent. Tenants can make repairs and subtract that amount from what they owe. Late fees were capped at $10. Codified this retaliatory eviction principle that says, if you evict someone after they complain, the presumption is that they did so as a way of retaliating against you. So the reason why this case is in your book is not because the reason why the case was brought. A constitutional challenge was brought saying that this law is a taking, that it violates due process, that's unconstitutional. So, Flora, what did the court say about the constitutionality of this law? Yeah, they upheld the law, right? So, 1 second. So, what's interesting is that in any given panel at the Court of Appeals, there are 3 judges in a panel, right? So, this panel is Judges Posner, Easterbrook, and 1 Judge Cudahy, who's kind of a liberal, right? These 2 are fairly, Posner was conservative, but not anymore, and Easterbrook is still fairly right of center, okay? Usually when there are 3 judges on an opinion, and they all agree that a law is constitutional, that's the end of the story. And they issue 1 opinion saying that this law is constitutional. But Matthew, we got something else in this opinion. What did we get in this opinion?
Did like an economic
Yes.
analysis.
Yes. So what's interesting is that the majority opinion was actually by Judge Cudahy, right? And he held for the court that this law is constitutional. But Posner and Easterbrook joined together and issued a concurring opinion going through all the economics of this case, right? Judge Cudahy wrote, quote, economic critique was not litigated and was at best superfluous. In other words, none of the parties raised these issues. It was totally outside the scope. And why are we even doing this? We're judges, not economists. But this has never stopped Judge Posner before. But basically, Posner says, well, there are 2 of us and 1 of you, so we're the majority. You can just hear him like dropping the mic. It's like, I'm out. Right, so this is Judge Posner. This is his MO, right? There are 2 of us, there's 1 of you, we win. I could use a word at the end that's
Oh, yeah, I was literally just gonna kind of comment on that. Literally, like, the issue is, like, that I see in a lot of opinions is judges fail to consider the economic ramifications of their judgment and they're only constitutional. But in this, they really just kind of, like, brushed off the constitutionality and just go into this, like, pseudo-intellectual, or I guess in their case.
Pseudo-intellectual, oh my God.
Rant.
This is Judge Posner will come and strike you down. He will smote you. I once wrote a blog. I once wrote a blog post about him. He actually emailed me and asked me to post a correction. I mean, he's. So pseudo-intellectual. Oh my. He'll be paying this to soon. Posting outside the record, right? So there was a case before the Seventh Circuit a couple months ago where the issue was, how much time does it take for a person working in a chicken processing facility to take off the protective gear and put it back on? So in other words, if you have a 30-minute lunch break and it takes you 10 minutes to take your gear on and off, it's in theory a 20-minute lunch break, and you're not being compensated for those extra 10 minutes of lunch, right? No one ever works as a butcher or anything like in a factory like that. So in other words, so there was a disputed fact, right, of how long it takes to take off this protective gear, put it back on. So what did Judge Posner do? What do you think he did? He bought for his law clerks the exact gear that the butchers have to wear. And in his chambers, he held what I called a judicial fashion show. I got in trouble for this one. He held a judicial fashion show. And he actually timed his clerks of how long it takes for to put this gear on and off. The problem, which maybe Marcel can speak to, is that when you are covered in chicken giblets, it's not so easy to take off a clean suit. Also, you have to wash your hands, which he didn't have time for. And the final thing is, there was only one sink in the room where they all had to line up and wait for the sink. So actually, I considered filing a brief in that case, but I realized you couldn't even file that kind of brief. Based on that poster went outside the record. And then he wrote this entire opinion explaining he was just confirming his curiosity, which I think was directed at me, but I'm not sure. Because it was in the ABA journal. So I made a big stink about this, so we have some beef. But anyway, this is Posner, right? So this tricky dicky, right? So this is Posner. Let's walk through it, because as a matter of economics, I am extremely sympathetic to what he wrote, right? So what is Jordan, in a nutshell, what is his argument about this law? Was this law designed to help poor tenants?
I don't think so.
How was it advertised? Was it advertised to help poor tenants?
Yes.
Will it actually help poor tenants?
Not really.
That's right. Why does Posner say this law will not actually help poor people? Let's walk through it. Rachel?
Okay, so basically you're increasing the cost to landlords because they're going to have to maintain their premises better, and then they shift that cost to tenants by raising rents. And then I think they also look for more, well, not poor tenants, to make sure that they can pay the higher rent, and also I guess.
Exactly right. So here's what Posner says, right? This is not a rent control statute, right? Nothing in this law caps the rent. So what you're doing is you're imposing all these costs on the landlord. You're saying, okay, you have to keep your interest deposits here. You can't charge late fees. You can't do this. You can't do that. Where do you think this money will come from, right? This is something which economists seem to always forget. When you impose costs on companies, the companies impose those costs on their customers. This is a very basic principle. When you tax companies, that money doesn't just materialize into thin air. It imposes costs on people downstream. So when you make it more expensive for the landlords to rent, housing will go up. This is not, I mean, as a matter of basic economics, it's true. Whether it works in this case, I don't want to go too far, okay? So what will end up happening? Rents will go up. Tenants will be harder to find apartments, right? Why? There'll be more screening. If it becomes harder to evict someone, then I'm going to be much more selective with who I put, right? I don't want to take a risk on someone with poor credit because they may default and they won't ever get paid for it, right? What else? The cost of housing will go up. If it becomes so much less profitable to have rental units, why don't I just convert my stock into condominiums and sell? This law does not apply to condos. So now this is a direct benefit to middle class people who can buy condos and harming poor people who can only afford to rent, right? Posner says that forcing them to deposit it in an Illinois bank is just a simple transfer of wealth to local businesses, right? This is the kind of provision that's a kickback to local banks, right? There's no reason why you need to have an Illinois bank holding these deposits, right? There's no reason other than to benefit local cronies, right? And Posner concludes by saying this is not in the interest of poor people. All these laws aimed at helping the poor people will simply just benefit the middle class. People will choose to buy rather than rent. And the losers in this case are the landlords and the poorest tenants. All right. And because there's no ceiling on rent. So a brief note on rent control, and I think Posner makes a statement in his opinion. Rent control is a terrible idea that virtually almost never, ever, ever makes sense. The reason why is it bestows a serious benefit on people who are already in an apartment and imposes the cost on everyone else around them. So thankfully, most cities have gotten rid of it. New York is actually one of the remaining fossils. A funny note, if you want to see a difficult test, try to compare cities with rent control versus cities that have been bombed by war and compare the burned out buildings. And it's very hard to see which is which. Because buildings under rent control have a very high rate of arson because it's much easier to destroy the building to get rid of the tenants than to evict them.
Does Thomas Sowell also teach
Yes.
School of Economics?
Thomas Sowell is an alum of George Mason, where I went to law school. So if you know Thomas Sowell, you probably know where I studied.
Because he's made these rent control arguments quite often.
Yes, yes, yes. So I suppose this is a fitting point to wrap up the semester. Everything has costs. Efforts to help people often shift to others. Okay? Thank you all so much for a wonderful semester. I'm very grateful. Thank you very much. Thank you. Thank you very much. All right. Please take the time. No, don't go anywhere yet. Please take the time for this evaluation. And I'll see you all on Wednesday. Great.